yes, but we're still waiting for some testing.
Jermaine Young, 240916. I decided to quit saying DCCR. I'm over it.
The first victim wastes no time, reminding the court that word can cut sharper than steel when weaponized.
All right, sir, are you Jermaine Young?
Yes, ma'am.
And Mr. Young is charged with aggravated sexual assault of a child. And Mr. Burbank, what is the announcement?
I think we're still waiting for some testing, Judge.
We are, Judge. I put a call in. I got a response on my DNA. That's the only thing. We had a CPS. We've received that.
Got that.
So this is the only thing that we're waiting on.
And did they give you any type of...
All through with them.
All right, let's do, we'll do, now that we've got CPS, that's the only thing we're waiting on. I'm going to do 60 days. And then hopefully we'll have some information, obviously when it gets close, if you can get back with them and see where we are. If we need to let them know some special setting to make it move up, then we'll see if we can get that done.
Yes, ma'am.
Stay in touch with Mr. Burbank. He'll let you know when you need to be back.
Yes, ma'am.
All right, we're free to go. Yes, sir. So I wonder where,
I borrowed some time, but I can't tie it.
it's all right, you're good. All right, are you Maverick Neal? And Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436. And what is the announcement?
Judge,
His hammering home a crucial point. The defendant had options. He could have called, emailed, or checked facts. Instead, he went straight to threats.
The complainant. I'm not getting any answers for written correspondence or the different phone numbers my investigators know to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll can double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if, sounds like there needs to be a rejection done, if there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neal, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024.
This is where misinformation bleeds into real danger. Fake outrage online turned into direct violent threats offline.
Punishment would be between 2 years and up to 20 years in prison. Do you understand?
yes, I do.
And I have here on the computer a plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your case, for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction. Do you understand? So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right, so if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence.
For Marcus, this isn't abstract. These weren't just angry posts on the internet. These were threats against his wife in their own home.
You don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct? Yes, you want to plead, or no, you don't want to plead. That's what we've been talking about outside.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding.
What are you not understanding?
It's been 4 times, right?
I don't know about 4 times.
He's talking about the docket call.
Okay.
The state had indicated to me that they might have, or I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. He feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with the case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct?
Victim statements like this are the justice system's gut check moment. Beyond statutes and sentencing, this is about fear, dignity, and safety.
They're going to present the evidence that they do have to a jury if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go to trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket. Mr. Doyle will begin preparation for trial.
Okay, do you have any ideas?
They'll send you that date. We're about
Okay.
3 months or so.
Okay.
Okay? Yes, sir. Thank you. You're free to
Thank
go.
you, Your Honor.
Mr. Bennett didn't have this setting in his calendar, and he hasn't made.
We're going on the lesser included robbery.
Thank you.
There are some misdemeanors that are out there that are going to be taken care of, so we're going to need to determine restitution on those misdemeanors as far as if there's any.
Good morning, sir. Are you James Ward? And Mr. Burbank, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Ward, in cause number 240541, you're charged, the state has elected to proceed on the lesser included offense of a second-degree felony.
Now the spotlight shifts. Another voice, another victim, each one echoing the same theme. Words matter, and threats leave scars.
That's from April 11th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to pay restitution that would be determined between now and when we come back for sentencing, and there would be dismissals in the misdemeanor cases. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection to one.
It's admitted. Any evidence that Mr. Ward's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll figure out restitution, and we'll come back later for sentencing. Yes, sir.
Your Honor, there's a case that was received by our office just a few weeks ago, not yet indicted, for evading with a motor vehicle. The offense date is from December of '24.
Okay.
Should that case get indicted, we will be running it concurrent with this.
Okay. If
I
it
don't
gets
think,
in-
I don't think a decision's been, or I don't think it's been presented to the grand jury yet.
All right. So obviously, if that case gets indicted, the understanding is that you would come in, we would do the same thing on that case, and you would have a probation that would run at the same time as this one. Is that your understanding? All right. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? We'll see you back at sentencing. Yes, sir.
Thank you, Your Honor.
Michael McCain. And good morning, sir. You are Michael McCain? And Mr. McCain, Mr. Vasquez is here for Mr. Macon. And have you had an opportunity to go over that PSI with him? And are you okay going forward today with your sentencing with Mr. Vasquez? And I've received that pre-sentence report. This is 241408. Has everyone had an opportunity to review that report?
Yes, Your Honor, just read.
Are there any additions or corrections to that?
No, Your Honor.
All right, Mr. McCain, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for a period of 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, and there's no reason for me to think you won't, this seems like it's something that's very out of character, and also something that even you admitted was because of some emotions that had to do with your child and ex and things like that. Obviously, you understand now this isn't the way to handle that, correct? If you do everything you're supposed to on this probation, it's an excellent opportunity because you don't have a felony conviction. When you successfully complete it at the end, the case will be dismissed. You'll never be a convicted felon. The other side to that, though, is if you violate your conditions of probation, you can be brought back into court, you could be found guilty of the offense, so you would be a convicted felon, and you could go to prison for up to 20 years because of this. Do you understand? Also, I want to make sure you understand as well, you got a 10-year probation. However, I sign every single day early terminations for people to get off probation early. And so that could very well happen, it looks like, with you. And if you do everything you're supposed to while you're on probation, get your community service done early, follow all of the rules, don't test positive for anything, don't obviously get arrested for anything else. Anyway, do everything you're supposed to, then you would be eligible early to get off probation. So make sure you do all of that and you don't have to worry about the whole 10 years. If you're not doing everything you are supposed to, then obviously you could end up on it for 10 years or you could end up with a revocation. You understand? All right, I'm handing you the trial court certification. It shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Thank you, Mr. Vasquez.
Thank you, Your Honor.
Well, I guess we're going to wait just a little bit longer to see if he shows up, and then we'll try to figure something out in just a little bit, ma'am. So don't let you can step right outside the courtroom, but don't go far unless I tell you can leave, okay? All right. We'll be in a short recess. I'll get it. Good morning. You're Kennedy Webb. And Ms. Webb, this is your initial appearance and cause number 25, DCCR 0258. You're charged with the state jail felony offense of either it's false alarm or reporting of an emergency from November 12th of 2024. And since you have made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, I have, but I can't afford it.
Are you working?
Yes, I recently just got a part-time job, and I'm also a full-time student still.
You are still. They didn't do anything with regard to that. As far as, are you still a student at Lamar?
No, I'm at a community college back in my hometown,
And where's that?
Arlington, Texas.
And what community college is it?
Tarrant County.
So I'm going to have you fill out some paperwork this morning, Ms. Webb, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Any income you might have, any bills that you have, put it all on there because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that information. Yes, ma'am. See, Mr. Boudreaux, you have a David Holland. Good morning, sir. You're John Van Wright. And Mr. Van Wright is charged in each of his cases with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, Brennan Mitchell filed an appearance this morning. He's going to serve as lead counsel in this case, and I'm going to take a step back as co-counsel.
It's obviously, if he just filed it, it takes time to get through e-file, so we don't see all of that yet. Any issues, Mr. Smith? So one of these is an MTRP and one of them is a new case. All right. No issues with regard to any contact or anything that we're not wanting? And probation's here as far as, for now, everything's going okay. Okay, I'll reset the case and Mr. Mitchell can get the information that you have, obviously, with regard to discovery. If there's anything else that needs to be turned over, we'll get an announcement at the next court date.
Thank you, Judge.
All right, thanks. If you'll make sure and get that request in.
Absolutely.
Thank you. You're free to go. Good morning. Are you Diamond James? And Ms. James, this is your initial appearance and cause number 25, DCCR 0437. Just a second. You're charged with a third-degree felony offense of hindering apprehension or prosecution of a known felon from March 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? No. So what I'm going to do, Ms. James, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They all have different payment plans. If you're sitting in here, you've heard it's not just a game to come in and tell me that you've write 3 numbers down. You need to actually speak with at least 3. The point of this is to try to hire a lawyer, okay? But bring me back the names of those that you've contacted and talked to so that I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would have to go back to jail. Do you understand? As a condition of your bond,